Hi, this is Todd Gulinson from the Todd Gulinson team and your Phoenix probate expert. During the probate process, there are 10 major defined executive duties that you as a petitioner either need to perform or you need to make sure that someone gets it done. The probate process in Phoenix, Arizona can be quite a long and arduous time period. It can take anywhere from a year to a year and a half to settle an estate. So what you want to do is take immediate action. After all, soon bills from the deceased estates will start showing up, and if you're not able to properly handle the financials immediately and efficiently, all of the heirs will lose. I have put together a new report entitled The 10 Executor Duties During the Probate Process. At the end of this video, I'm going to explain how you can order this special report of all 10 duties. Right now, I'm going to go over the first 3 you should know about right now. Number 1, the very first thing you want to do is read the will. After reading the will, there are 2 things to do immediately. A, talk to members of the deceased family and other interested parties who desire information. You want to know if there are any members of the family who have any information on the deceased assets, as well as anyone outside of the will who might be claiming any rights to the will. B, you are going to want to confer with the estate's attorney and other people that are familiar with the deceased financial affairs, such as his or her CPA or insurance agent. That's just step 1 of 3. Number 2, safeguard the deceased assets. Take such immediate protective measures as are desirable prior to your appointment as executor of the will. This area falls into 4 specific jobs or duties. A, ensure the protection of both the real estate and the personal property. What does this mean? Well, has a person's residence been sitting vacant? Do they own any rental properties? Are there any vendors who have keys to the home or homes, such as cleaning people, pool people, the gardener, the painter, the pet sitter? Likewise, you want to secure the personal property. Are there any keys to the cars hanging around the home? Is there a jewelry around the house or in a safe deposit box? Are there any expensive musical instruments or artwork? B, secure knowledge of the deceased's ongoing business interests. For example, does the deceased own any stocks, mutual funds? Do they work with a financial advisor or planner who is managing their money? Do they have any business partners to contend with? So understanding the deceased's financial affairs and taking control of them is an incredibly important part of the job. C, examine the deceased's books and files. You need to do this right away in case there are taxes to file or important financial information that has to be acted upon immediately. And D, the last important part of the safeguarding of the assets would be to give notice of the deaths to the banks, safe deposit companies, and other parties of interest. Now, step 3 out of 3 of the 10 things to do as executor of the estate, you want to petition the court for probate of the will. What does this mean actually? First of all, what is a will? A will is a legal document that sets forth the deceased person's wishes regarding the distribution of property and the care of minor children. However, a will in of itself has no authority. So in order to create authority, the court has to stand behind the deceased wishes in the will. Probate is the court's supervised process of authenticating a last will and testament of the deceased, if the deceased made one. In other words, it gives the will meaning and therefore power. It includes locating and determining the value of the decedent's assets, paying his final bills and taxes, and finally distributing the remainder of the estate to his rightful beneficiaries. A couple other important words to understand in this process. Interested party. An interested party is someone who may benefit from the probate or the authentication of the will. And the petitioner or the executor of the will is the one who is in charge of carrying out the wishes in the will with the backing of the court. So, after you have read the will and safeguarded the assets, you will want to petition the court for probate of the will. In the process of doing this, you will also be applying for all paperwork to execute the wishes in the will. The paperwork is called letter of administration or letters testamentary. Those are the same thing. Letters testamentary is what gives you as petitioner either full or partial authority to sell the real estate, handle the financials of the deceased, pay off debts, and allows you to move through the rest of the probate process. So there you have it. Those are just 3 out of 10 of your duties as a state executor or petitioner. To find out about all 10 of these, you can grab a copy of this report for free by emailing me, calling me directly, or if you are more comfortable, you can call the 24-hour free pre-recorded hotline and just leave your request there. Thank you.